India borrowed the idea of independence of judiciary from USA. India borrowed the idea of independence of judiciary from USA. In Britain, the law made by the British Parliament is final. There is no judicial review in Britain. In Britain, the law made by the British Parliament is final, and there is no judicial review in Britain. Whereas in India, if the law is made by the Parliament or state legislature, the judiciary have every power to review it. And if the law is violative of fundamental rights, the judiciary can declare it as null and void according to Article 13. Article 13 gives implied power to the judiciary of judicial review. Article 13 provides implied power to the judiciary of judicial review. In Article 13, you don't find the word judicial review. Nyaya Samiksha ane మాట 13 లో లేదు. In Article 13, you don't find the word judicial review. But Article 13 says, laws inconsistent with the fundamental rights chapter are void. Laws inconsistent with the fundamental rights chapter are void. So, Article 13 impliedly gives review powers to the judiciary. And in India we have independence of judiciary. In India we have independence of judiciary. You all know, till date, in Supreme Court or High Court, no judge was removed. In India, independence of judiciary is maintained exceptionally. In India, independence of judiciary is maintained exceptionally. Free, fair and impartial judiciary is a backbone of a democracy. Free, fair and impartial judiciary is a backbone of democracy and federal structure, where only an impartial judiciary can maintain people's rights properly. Only an impartial judiciary can maintain people's rights properly. So, one of the important things for impartial judiciary was security of tenure for judges. Security of tenure for judges. It's very difficult to review a judge because judge has to deliver his free judgment without fear or favor. Judge has to deliver his judgment without fear or favor. So, the removal of the judge is not in the executive hands. Either Supreme Court judge or High Court judge, they have to remove by parliamentary resolution. They have to remove by the resolution in the Parliament. And according to Article 124, the resolution for the removal of the judges should be passed in both houses of the Parliament. In the both houses of the Parliament. Very difficult to remove a Supreme Court or High Court judge. There is the same process. Open 124 once, there is the same process for the removal of the Supreme Court judge and High Court judge. First thing is, security of tenure for the judiciary is guaranteed. Till date, on two judges, Justice Ramaswamy and Justice Soumitra Sen. Till date, on two judges, the removal proceedings started. By the time the proceedings got concluded, they both resigned. So, on two High Court judges, Justice Ramaswamy and Justice Soumitra Sen. Listen. A judge of the Supreme Court shall not be removed from his office. Section 1 Section 120, Article 124 Class 4. Article 124 Class 4. A judge of the Supreme Court shall not be removed from his office except by an order of President. Except by an order of President passed after an address by each House of Parliament, supported by a majority of total membership of the House, and not less than 2/3 of the members present and voting, has been presented to the President that the judge should be removed. That the judge should be removed. See, it's very difficult to remove a judge. Very difficult. And judge will be given an opportunity to present his case of the other house. Judge will be given an opportunity to present his case of the other house. So according to Article 124 Class 4, removal of judge is very difficult process. It is not completely in the executive hands. Why? Because if it is in the executive hands, then judiciary might become biased. Judiciary might become partial. And executive, ministers, government can influence the judiciary. So, for that reason it has made. First thing for security of tenure, first thing for independence of judiciary is security of tenure. Second thing, judiciary has been given the power to punish others for contempt of court. To punish for contempt of court. Article 129 and Article 215. 129 for the Supreme Court, 215 for the High Court. So, Supreme Court is a court of record. It has the power to punish for its contempt. Supreme Court is a court of record. It has the power to punish for its contempt. High Court is a court of record. It has the power to punish for its contempt. So, contempt powers. Next, Article 50. Article 50 of the Indian Constitution says there is a separation of executive from judicial. Separation of powers. Article 50. Executive and judiciary are separated. Article 50. And as I told you few minutes back, Article 121 and Article 122. Article 121, Parliament should not interfere in the affairs of the courts. Article 121, Parliament should not interfere in the affairs of the courts. Article 122, Court should not interfere in the affairs of the Parliament. Article 121, Parliament should not interfere in the affairs of the courts. Article 122, Court should not interfere in the affairs of the Parliament. In the same way. In Article 124 itself, after retirement, the judges of the court, the judges of the Supreme Court are not allowed to practice. Article 124. No person who has held office as a judge in the Supreme Court. 124 Class 7. See, whenever you are writing 40 answers, you should mention articles. 124 Class 7. No person who has held office as a judge of the Supreme Court shall plead or act in any court before any authority within the territory of India. No person who held office in the Supreme Court as a judge shall plead or act before any court. 124 Clause 7. Okay. So, it's very difficult to remove a judge. And separation of powers, Article 50. Contempt of court, Article 129. Okay. And 121, Parliament should not interfere in the affairs of the courts. Judges should not plead or act in any court. 124, Clause 7. So, all these articles ensure independence of judiciary. Apart from that, in 124, in Article 124, we have an important thing. The judges of the Supreme Court are appointed by the President after consulting such other judges as he may think fit. Here, President has to consult the judges before appointing the judges. So, there are 3 cases which you have to remember. Judges transfer case 1, judges transfer case 2, judges transfer case 3. There are 3 cases, very famous. Judges transfer case 1, judges transfer case 2, judges transfer case 3. So judges transfer case 1 also called as SP Gupta case. Judges transfer case 1 also called as SP Gupta case. Judges transfer case 2 also called as Supreme Court Advocates on Records Association case. Supreme Court Advocates on Record Association case. Judges transfer case 3. Judges transfer case 3 also called as in re presidential reference case. In re, that is advice. President's advice to Supreme Court. In reference, in re, INRE. In re means President's advocate advice to, asking advice to the Supreme Court. In re presidential reference case. So judges transfer case 1, judges transfer case 2, judges transfer case 3. Also called as first judges case, second judges case, third judges case. First judges case 1981, second judges case 1993, third judges case 1998. 1991, 1993, 1998. Okay? Now, in first judges case, SP Gupta case, okay, there was a primacy of executive over judiciary in judicial appointments. Primacy of executive over judiciary in judicial appointments. What do you mean by this primacy? See, President may consent judiciary. President may deny the opinion of judiciary on cogent reasons. If there are strong reasons, President can appoint somebody else. President need not bother about judicial recommendation. For example, President consent judges. Judges give recommendation. President can refuse that for some reasons, for some cogent reasons. In SP Gupta case, executive means here President is supreme than judiciary in judicial appointments. This is the judges transfer case 1, also called as SP Gupta case 1981. Okay? So President has more power over the judiciary. SP Gupta case 1981. Now, second judge's case, Supreme Court on Records Advocates on Records Association case. Supreme Court Advocate on Record Association case, where Supreme Court told no. Judiciary has primacy over executive. Judiciary have primacy over executive. Judiciary have more powers in judicial appointments than executive. President has to consult collegium, a group of judges. Collegium, a group of judges. In which case it was told? Second judge's case. President should consult collegium. Okay, 1993. In second judge's case, the word collegium was used and President has to consult collegium, and the recommendation given by the collegium should be followed by the President. And then in 1998, the then President K.R. Narayanan, in 1998, the then President K.R. Narayanan asked the Supreme Court, collegium means what? How? The Supreme Court told, collegium means 4 senior most judges. Collegium means 4 senior most judges. Collegium means 4 senior most judges, and they should give their recommendation in writing. They should give their recommendation in writing. If any 2 judges say no to the particular candidate, that recommendation should not be sent to the government. If any 2 judges say no to the candidate, that recommendation should not be sent to the government. Collegium means 4 senior most judges. They should give their recommendation in writing. This was told in 3rd case 1998. So from 1998 to 2015, from 1998 to 2015, collegium method was followed. 1998 నుంచి 2015 వరకు collegium method follow అయ్యారు. In 2015, 99th Constitutional Amendment Act was made. In 2015, 99th Constitutional Amendment Act was made. In 2015, 99, inducting NJAB, establishing NJAB, National Judicial Appointments Commission. NJAB, NJAC, National Judicial Appointments Commission. And later on, the 99th Constitutional Amendment Act creating NJAB was struck down by the Supreme Court. 99th Constitutional Amendment Act was considered as unconstitutional. 99th Constitutional Amendment Act, it was considered as unconstitutional. It was considered as unconstitutional. Okay? 5 judges bench. 4:5 judgment. 4:1. 4:1 judgment. 5 judges, 4:1. The dissenting judge was Justice Jasti Chalameshwar. The dissenting judge was Justice Chalameshwar. You know what he told? Transparency is the backbone of democracy. Judiciary is not an exception to it. Transparency is the backbone of democracy. Judiciary is not an exception to it. ప్రజాస్వామ్యంలో పాటిస్తుండాలి, న్యాయ వ్యవస్థ అందుకు అతీతం కాదు. But the remaining 4 judges told NJAB is unconstitutional because in NJAB there will be law minister, there will be 2 outsiders. Why they should involve in judicial appointments? And they said, let us continue collegium method. And even today, judges are appointing judges. Collegium method. Even today, judges are appointing judges. That is collegium method. So first judge's case, second judge's case, third judge's case. Judges transfer case 1, judges transfer case 2, judges transfer case 3, 99th Constitutional Amendment Act, NJAB, and making NJAB unconstitutional 2015. Now again we are following collegium method. This is how appointments, transfers, all these things were made. Collegium. 4 senior most judges should give the recommendation in writing. Okay. 124 maximum in the process. Coming back. Judicial activism and judicial restraint. Judicial activism and judicial restraint. RESTRAINT. Judicial activism and judicial restraint. See, law is important, judiciary is important, democracy is important, justice is also important. Justice, democracy, law are all the important concepts. Think that we have law but no democracy. Think that we have law but no democracy. There will be police constable but there won't be democracy. There will be strict laws, it will become tyranny. It will become tyranny. Strong control. People will get suffocation. think that there is democracy, but there is no law. People can do what they want. There is no regulation. It will be anarchy. It will be anarchy. Think that people can go anywhere without traffic constable, without fines. Then people generally will not give way to affluence also. It will end up in anarchy. Democracy without law is anarchy. Law without democracy is tyranny. What we need is a balance between law, democracy and justice. What we need is a balance between law, democracy and justice. As a famous writer, Jeremy Taylor, Jeremy, Jeremy Taylor said, a famous writer, Jeremy Taylor said, a herd of wolves, herd means group of wolves, a herd of wolves, WOLFS, are quieter and much better than humans without law. A herd of wolves are quieter and much better than humans without law. I'll just give the meaning. You will be going in the countryside, cycle, car, motorcycle. Suddenly, cows, buffaloes, calves, goats will come in between. And you will be thinking they don't have sense. Right? If there is no law, humans behave more worse than this. A herd of wolves, a herd means group of wolves, are quieter and much better than humans without law. A herd of wolves are quieter and much better than humans without law. Okay, so what we need is law and also democracy. And judiciary has to protect both. Has to regulate law and also has to protect people's rights. And when something grave is going on, when some gross injustice is going on, judiciaries will not sit in an ivory tower like an Olympian, closing its eyes, uncaring to the needs of the society. When some gross injustice is going on, we cannot expect judiciary to close its eyes. There are three organs of the government: legislature, executive, judiciary. The three organs should work within their domain at the same time, should also be active. When the two other organs are inactive or in hibernation, judiciary will activate itself to activate the other organs of the government. This activism is called judicial review, judicial activism. This activism is called judicial activism. The active role played by the judiciary to protect the basic rights of the citizens, basic tenets of the constitution, and also to give some inertia to the hibernating other organs is called judicial activism. And there are many roles of judiciary: interpreting the constitution, interpreting the laws, enforcing the laws, interpreting the constitution, interpreting the laws, enforcing the laws, beyond everything else. Sometimes it is making laws in the name of precedents. Precedent means previous judgment. It will give a judgment. If you don't follow it, contempt. Almost it is making the laws. Almost it is making the laws. Most of the law today is nothing but basically judicial guideline. For example, Vishaka versus State of Rajasthan guidelines have become the source of Prevention of Sexual Harassment in Working Places Act. Now, even Supreme Court directions regarding liquor, regarding electoral reforms, most of the things have become laws now. Now the thing is, can the judiciary do this? Is the judiciary right? Can the judiciary do this? Is the judiciary right? Is the question. Here, in the initial days, in Shankari Prasad, Sajjan Singh, Champakam Durayarajan, A.K. Gopalan. In all these cases, Supreme Court followed a very narrow road, a very restricted interpretation, and a very narrow perspective. Just it confined to the four points, basic tenets, rigid framework. It has never given an overarching judgment. It was confined to literal interpretation of the text. It has been confined to literal interpretation. In beginning cases, it was very narrow. First lo chala narrow alochichedi. In the initial cases, it was very, very narrow. But Keshavananda Bharati was the state of Kerala. The basic structure of the constitution cannot be changed. 1973. Indira Gandhi versus Raj Narayan. Rule of law. From Prime Minister to the peon. Law is applicable to all. 1975. Maneka Gandhi. Right to go abroad is a part of personal liberty. Personal liberty after Maneka Gandhi have seen new vistas. Mills, judicial review is a basic structure. S.R. Bombay, secularism is a basic structure. From environmental rights, Ganga water pollution case, prisoners' rights, Sunil Batra case, a postcard has been accepted as PAL. Husainara Khartoum, speedy trial. Husainara Khartoum case, speedy trial. Vishaka versus State of Rajasthan, prevention of sexual harassment in working places. Recent cases, Common Cause, 2018. Common Cause versus Union of India. Passive euthanasia, right to die with dignity. 2017, Puttaswamy versus Union of India, right to privacy is a fundamental right. There are various cases where Supreme Court protected the human rights, basic fundamental rights of people, expanded the domain of human rights, curtailed the intervention by the government. Curtailed the intervention by the government, expanded the domain of human rights, and contained the intervention of the government. In all these cases, the Supreme Court's performance is laudable. Many have given accolades to the Supreme Court. It was really strong and steadfast in protecting the rights. In fact, public interest litigation has become a new bastion in the hands of judiciary to open the doors for the people who cannot reach the Supreme Court, higher judiciary. It has opened the doors. It has created a new entrance to the pool, to the problems of the pool, in the name of PAL. To all this extent, we are fine with judiciary. We are happy with judiciary. But, see, already Krishna Swami Iyer said, judiciary is not super legislature or super executive. Judiciary is not super legislature or super executive. Former Chief Justice S.P. Balucha once publicly lamented. Former Chief Justice S.P. Balucha once publicly lamented. He once publicly lamented. 20% of higher judiciary, at least 20% of higher judiciary is corrupt. There are many statements. Now, is judiciary overacting? Recently died Somnath Chatterjee, the former Speaker of Lok Sabha, said, judiciary is crossing its Lakshmana Rekha. Judiciary is crossing its Lakshmana Rekha. The former Prime Minister Manmohan Singh said, the judiciary is overarching. The judiciary is overarching. So, why this criticism? To the extent of protecting of human rights, basic fundamental rights, and basic tenets of the Constitution, nobody is actually worried. But the real problem is judiciary encroaching into other domains. The real worry is judiciary encroaching into other domains, entering into everyday working of BCCA. Asking Somnath Chatterjee, the then Speaker of Lok Sabha, to come and attend before it. In order of precedence, Chief Justice of India and Speaker of Lok Sabha have same stature. They have same stature. But he asked the CJ asked the Supreme Court, CJ asked the Lok Sabha Speaker to come and attend before it. And judges are not democratically elected body. They are appointed body. Their role is to interpret the constitution. Public representatives should make law for the people. Public representatives should make law for the people. But instead, judiciary is making law for the people in the name of precedence. If you don't follow it, contempt. If you don't follow it, contempt. In the same way, we have all vices in judiciary, including corruption. Already in judiciary, there are lakhs of cases are pending. Lakhs of cases. Instead of cleansing itself, judiciary tries to cleanse the other organs of the government. This is one criticism. Instead of cleaning itself, it tries to clean the other organs of the government. As you all know, there is a famous quote: delayed justice is nothing but denied justice. Delayed justice is nothing but denied justice. And in the judiciary, law needs evidence always. Law needs evidence always. They don't give judgment without evidence. Administrative difficulties are different from paperwork. They can say everything on paper and give judgment. In the administration, we will understand the real problems. In the administration, we will actually understand the practical problems. In the judiciary, the judges are devoid of practical difficulties. They are academicians. They don't know the administrative difficulties. So all these things make judiciary. People criticize it for excessive intervention on other powers, like legislature and executive. In a democracy, legislators are meant to make laws, not the judges. We have not elected the judges. But judges think that they are from heaven. Judges are also humans. They also have human fallibilities. Judges are also humans. They also have human fallibilities, human weaknesses. So, in exceptional cases, we can agree that judges can judicially intervene, but not in every day, in every affair. Unless it plays a gentleman's role, the sanctity and supremacy of the judiciary can never be maintained. Only when it follows a restraint, there can be permanence in the judicial judgments. Otherwise, social revolution is not forever. And if you see entire judgment, if you see latest 4 judges revolting against the CJI, if you see 3 months back, 3-4 months back, 64 parliamentarians, Rajya members, giving a notice to Vice President, asking for the removal of Supreme Court Chief Justice, the internal disturbance in the judiciary, all these things shows unless there is a restraint, unless there is a cleansing, unless there is a transparency, a social revolution is not far away. It is not far away. Now, this is a main discussion. నేను ఏం చెప్పాను రాసుకున్నారా? Just read it once.